Yes, what I wanted to mention was I've been covering this. So this shooting happened October 21st, 2021. My first post on this, you can see in the bottom right-hand corner here, was October 22nd, 2021. And I've been covering it ever since. There's 6-7 blog posts here. There's more content here. Here's my interview with Adam Baldwin. Again, only law self-defense members will be able to access that here. So I've been doing coverage of this since it originally happened. And what I'd like to do is actually rewind the clock all the way to the day after the shooting, October 22nd, 2021, and go over some legal concepts that I think might be helpful for everyone to understand. So let me pump this up, as they say, and go through some of this. So we're sharing a tragic story out of New Mexico involving Alec Baldwin, who I'm sure we're all familiar with at this point, in the shooting death of Helena Hutchins on the set. Helena Hutchins, then 42 years old, a wife and mother, was killed. Also, a director, Joel Souza, 48 years old, was injured. The round that was fired, the single round, passed through Helena Hutchins and struck Joel Souza, was actually recovered from just under the skin on Joel Souza's back. So Joel Souza was injured by the gunshot, but not killed. And of course, I got a lot of inquiries about this. One of the questions would be, what's the maximum potential legal liability for Alec Baldwin? And it would be involuntary manslaughter under New Mexico law, which is normally punishable by up to 18 months in prison and a $5,000 fine, which doesn't seem like a lot of time for involuntary manslaughter. In most states, the punishment could be substantially greater. But there we go. I can't recall now if there's firearm sentencing enhancement type of things for involuntary manslaughter. I think there are under New Mexico law, but I don't think they're applicable to Alec Baldwin's scenario. I think the prosecutor did originally bring those, but ultimately dropped them. And as I recall, my analysis was they were appropriately dropped. So there's various kinds of legal culpability, legal responsibility that can be asserted depending on the nature of the underlying act. And here we can think of the various options as accident, negligence, a concept called criminal negligence, and recklessness. So an accident is a bad outcome that was in some way triggered by you, but for which you ought to have zero responsibility, zero legal responsibility. And the zero legal responsibility is largely a function of the complete unpredictability of the bad outcome. So to illustrate, you have an elderly aunt, lives in an apartment. You go up to her apartment to visit, and she asks you, hey, can you move that bureau from one side of the room to the other side of the room? So you're a big, strong young man. So you pick up this heavy bureau, you pick it up from one side of the room, you move it to the other side of the room, you put it on the floor of the apartment, and unbeknownst to you, impossible for you to know, not apparent in any way, the floor joists on the other side of the room are rotten from termites, and the bureau falls through the floor into the apartment below, lands on another old lady, and kills her. What should be your legal responsibility for the death of that other old lady? Well, it should be zero, because this is a genuine accident. You were conducting yourself in a lawful manner. It was completely unforeseeable, unpredictable by you that a bad outcome would result. A bad outcome did result. Somebody died as a result of your conduct. But because it was unpredictable, unforeseeable, and of course there was no malice in your heart, in your mind, there's zero legal liability when there is a genuine accident of this type. Then we have negligence. Negligence occurs when you were also not aware, you were not consciously thinking that there's a potential bad outcome from what I'm doing, but you, a reasonable and prudent person in your circumstances, would have predicted the potential of a bad outcome. So you weren't consciously thinking about a bad outcome, but you should have been thinking about it. And an example of this might be someone who is driving too fast in the rain, or driving while looking at their cell phone, for example. And you're not thinking when you're doing that, hey, if I do this, I'm increasing my chances for an accident. That's not in your mind. But a reasonable and prudent person, a cautious person, would have been thinking that. And therefore, because you should have known of the risk, even though you weren't thinking of it, that creates negligence liability. Now, negligence liability is not enough for criminal liability. Negligence is only enough for civil liability. So it's not enough for prosecution, but it is enough for whoever you've injured to sue you in civil court, recover money for their damages. There's another concept called criminal negligence, but I'll come back to that in just a moment. First, I'd like to talk about the next higher level of mental culpability, which is recklessness. So negligence is where you're not consciously aware of the risk you're creating. Recklessness is where you are consciously aware of the risk you're creating. So you're intentionally creating a substantial and unjustified risk of, let's talk about death to another person. You ignore that risk and death results. That's a reckless homicide. That's involuntary manslaughter. That's what reckless manslaughter is, involuntary manslaughter. You never intended to hurt anybody, which would be voluntary manslaughter or potentially murder. There was no intent to hurt. But you knew you were creating a substantial and unjustified risk of death to another. You ignored that risk and death resulted. And the classic example of a reckless manslaughter would be drunk driving death. So you go to a bar, you get drunk, you get behind the wheel of a car to drive home. You're not intending to cause anyone's death. You don't want to hurt anybody at all. You just want to get home, go to sleep. So there's no intent to harm. But we all know that when you get drunk and get behind the wheel of a car, you're creating a substantial and unjustified risk of death to another person. And by engaging in that conduct, you're deliberately ignoring that risk. If you do run someone over and kill them, that's a reckless homicide, involuntary manslaughter. Now, some states may call it vehicular homicide, whatever, but the underlying legal doctrine is recklessness. The knowing creation of a substantial and unjustified risk of death, ignoring the risk causing the death, involuntary manslaughter. Now, there is a flavor of negligence that sometimes is referred to as criminal negligence that does. So step back. Where negligence only creates civil liability, recklessness is where you get to criminal liability. So now you can be prosecuted. There is kind of an intermediary here, a form of negligence that's referred to as criminal negligence, which seems weird, right? Because negligence is only good for civil liability, but now we're talking about criminal negligence. Well, criminal negligence occurs when you're like negligence, you're not consciously thinking about the risk you're creating. A reasonable and prudent person would be aware, so you should be aware, but you're not consciously thinking about it. So it's not recklessness, but you're engaged in negligence while you're handling an inherently dangerous instrument. Explosives, heavy equipment, chemicals, dangerous chemicals, and firearms. It's almost impossible if you kill someone unintentionally with a gun, because a gun is an inherently dangerous instrument, and we all know it is. You'd have to come from outer space, never have seen a gun before, to not know guns are inherently dangerous instruments. It's almost impossible to unintentionally shoot someone with a gun and not have criminal liability. I mean, can we think of a hypothetical? Sure, I guess. I mean, could it be an accident? So it was completely unforeseeable. Maybe if you were handed a box and told, carry this box across the room, put it on that shelf, and unbeknownst to you, there was a loaded gun in the box, and on the way, someone bumps into you, you drop the box, and it hits the ground, and the gun discharges. I guess that could be an accidental death while you're, quote unquote, handling a firearm. But obviously, you didn't even know there was a firearm in your possession under that scenario. With negligence, you can't really have a purely civil negligent death with a firearm if you know you're handling a firearm, because firearms are inherently dangerous instruments, and that automatically bumps the negligence up to criminal negligence. So it creates criminal liability. most likely, of course, is your handling of the gun, because to cause a death to someone, you have to point it at someone and pull the trigger. On any modern, normally functioning firearm, they don't just go off by themselves. They don't have they're not sentient. They don't make the decision to fire. You have to have pointed the muzzle directly at another person and operated the trigger to get the gun to discharge. That's going to be recklessness. The knowing creation of a substantial unjustified risk of death to another. So what was Alec Baldwin's situation? Accident, negligence, or recklessness? Well, it's not an accident, because it's not unforeseeable that if you point a gun at someone without ensuring that it's unloaded, that the gun could discharge and kill them. It's not negligence, only civil liability, because you know you're handling an inherently dangerous instrument. It's either criminal negligence or recklessness. And in both cases, the legal outcome would be the same. It would be involuntary manslaughter. Let's see. So that was pretty much the end of that analysis. That's where Alec Baldwin's liability comes from.